Good evening to one and all present here. Meeting is called to order. Our MMBA feels immense pleasure and joy to welcome you all in this lecture series conducted by Infotainment Club. Our MMBA, through various clubs, used to conduct these types of lecture series to instill values, knowledge, communication in the minds of young advocates. One such club is an Infotainment Club, conducting its 4th session after its inauguration in this evening. Welcoming is the noblest acts of any function. By welcoming, we make the persons feel as at home amidst us. May I now request our Infotainment Club Chairman, Mr. V.J. Kumaravel, to deliver welcome address.
My golden evening greetings to you all for your coming here. Actually, this is the Mmba Infotainment Club 4th session event program. The special lecture is on emerging trends in electronic evidence. Here, I am in a position to mention the special qualities of our special guest today. His Lordship, Hon'Ble Mr. Justice S. Sounthar is known for his equanimity, erudition and obeisance to our Indian legal system forever. So, I am also eagerly waiting like you all to have his session with an enthralling and scintillating manner. I leave the podium for His Lordship, Honorable Mr. Justice S. Sounthar. Thank you.
Thank you, sir, for warm welcome. Act of honor come from honor written upon the heart. May I request our President, Mr. Srinivasa Raghavan, MMBA, to honor our Honorable Mr. Justice S. Sounthar with the memento as a token of respect. Thank you, Lordship. Thank you, sir. It is a great pleasure to welcome such a noble personality as our chief guest on today evening. Welcome, Lordship. Our chief guest doesn't require an introduction as he is a well-recognized person among us. His Lordship, known for his profound knowledge in every part of law, civil, writ, criminal, appellate side, labor and service matters, to say in one word as an all-rounder. His Lordship alma mater was Dr. Ambedkar Law College, Chennai, and joined office of Honorable Mr. Justice A.S. Venkatachalamurthy, retired Chief Justice of Chhattisgarh High Court. Now I request our Honorable Mr. Justice S. Sounthar to grace us with a wonderful lecture series.
Good evening to one and all. The passage of Information Technology Act paved way for recognition of electronic evidence in Indian legal system. In fact, the UN General Assembly passed a model law on electronic commerce in 1997. As our obligation to United Nations, our municipal legislature, namely the Union Parliament, passed Information Technology Act. We store information for future reference. The first and foremost tool known to human being to store information technology is our brain. In those days, the information passed on from one person to other only by words. We didn't have technology of storing information in documents. Slowly, we started storing information in stone inscriptions. Later on, it was replaced by palm leaves. In 19th century, there was revolution in storage of information, that is invention of paper print. Lastly, in the latter part of 20th century, we started storing information in digital format in electronic devices like computers, etc. In latter part of 1980s, the usage of computer picked up in our country that necessitated passage of Information Technology Act. This enactment mainly made 3 amendments to Indian Evidence Act. Section 3, definition of evidence was amended. We all know there are 2 kinds of evidences, oral evidences, documentary evidence. As per the amendment introduced to Section 3, document includes electronic records. Electronic records produced for inspection of courts. Then Section 59 was amended, which says there cannot be a oral evidence to prove the contents of the documents. Now, as per the amendment, oral evidence is not permissible to prove the contents as well as electronic records. Thirdly, section 65A and B were introduced. It lays down certain conditions for producing electronic records before the courts. Especially section 65B 4 requires production of certificate by a competent person. The certificate should also satisfy the various conditions mentioned in 65B2. The first case reported in electronic evidence is the very famous case law, Parliament attack case, Afzal Guru case. That is reported in 2003 Supreme Court cases online, Delhi 935. Subsequently, on appeal, it is known as Navjot Sandhu. In Afzal Guru case, computer outputs in the form of call records were relied on by the prosecution to prove phone calls from the persons directly involved in the attack and in the masterminds. Certainly, computer outputs cannot be treated as primary evidence. It can only be treated as a secondary evidence. The computer in which the original information is stored is primary evidence. Any output from the computer can only be treated as a secondary evidence. Section 59 bars oral evidence to prove contents of the document. However, in Afzal Guru case, the Delhi High Court held electronic records in the form of printouts can be proved by oral evidence of persons who produced those printouts before the court. The matter went to Supreme Court in National Capital Territory of Delhi versus Navjot Sandhu, reported in 2005-11 Supreme Court cases, page 6. In this case, two witnesses from telecom companies were examined. The official of Airtel and SR were examined to prove the printouts from computers, which contain the details of calls made by accused persons who involved directly in the crime to the masterminds. Supreme Court also affirmed the view of the High Court and said if the persons who produced the printout before the court are examined, that is sufficient. He is a person well acquainted because the primary evidence cannot be used easily. It will be stored in large servers which cannot be moved easily and produced before the court. Therefore, even under unamended law, secondary evidence is admissible through oral evidence. The concept under section 65 was borrowed and said secondary evidence in electronic form can be proved by oral evidence. But that view was not accepted subsequently in Anwar PV versus PK Bashir. Three-member bench of Supreme Court said section 59, 65A and 65B are complete coordinates. It is a special provision relating to electronic evidence. Therefore, whenever electronic records are produced before the court, that special provision should be followed. It is settled law. The special law will prevail over the general law. Therefore, the three-member bench said production of certificate as required under section 65B is sine qua non for admitting electronic records. Suppose what will happen if the primary source of information is in custody of opposite party? He will not issue certificate. Under section 65B, the person issuing certificate must be competent to, he must have control over the device. Then only he can issue certificate. He must identify the device. He must certify the information were properly fed into the device and retrieved properly. He must also certify the device was in a good working condition at the time of feeding information into the device and retrieval, etc., etc. Just to avoid manipulation, this kind of certificate is required under section 65B. At the most, it can only be an enabling provision because while we rely on certificate issued by a human being, there is a possibility for issuing a false certificate. Unless person who issued certificate is subject to cross-examination, how can we believe the certificate issued by him? Under section 65, the oral evidence is permissible to lead secondary evidence. A copy of the document can be produced by the competent person. He can prove the document. In that case, he will be subject to cross-examination by the opposite party. As far as section 65B is concerned, that is dispensed with. It is a luxury conferred by the legislature on electronic evidence. A person who wants to lead electronic evidence can simply produce the certificate 65B and walk away. He need not examine the author of the certificate. Sometimes the competent person would be under the control of the opposite party. In such cases, how he will be in a position to get the certificate? He may have the secondary evidence with him. A copy of the information retrieved from the original device may be in his hands, but he may not be in a position to produce it before the court for want of certificate under section 65. Then comes Tommaso Bruno versus State of Uttar Pradesh, 2015, 7 Supreme Court cases, page 178. In this case, CCTV footage was relied on to prove the guilt of the accused. Here again, a 3-member bench of the Supreme Court, without referring to earlier Anwar PV, said oral evidence is permissible. The electronic device, in the absence of certificate under section 65B, the electronic records can be proved by oral evidence. However, the 3-member decision in Anwar PV versus Bashir was not referred to in Tommaso Bruno. Whereas it relied on Afzal Guru case, that is Navjot Sandhu. We know the consequence of failure to refer to the binding precedent. In a subsequent case where election petition, nomination papers of certain candidates were challenged on the ground, those nomination papers were submitted after expiry of the cut-off time. Last date of nomination, the papers have to be submitted to the returning officer before 3 p.m. The nomination papers were submitted only by 3:53 p.m. Those papers were accepted by the returning officer. That was challenged in an election petition. In order to prove the nomination papers were filed after 3 p.m., they wanted to rely on video footage. Video footage was produced before the court. Relying on that, the High Court held, not only based on that video footage, based on some other evidence, High Court held the nomination papers were presented subsequent to the expiry of the time, therefore it should have been rejected. The election petition was approved. That was challenged before the Supreme Court in Arjun Pandit Rao Kotkar versus Kailash Kushan Rao, 2020, 7 Supreme Court cases, page 1. Now, the conflicting decisions were referred before the court, both by 3-member bench. Anwar PV, that another Tommaso Bruno. Before this case, yet another case that Shafi Muhammad versus State of Haryana. Here also, this particular question came up before the court, whether suppose if the person who is in possession of the secondary evidence is unable to produce the certificate, what should be the position? The 2-member bench of the Supreme Court said in such cases, taking into consideration the cause of justice, oral evidence can be allowed. All these decisions were relied on before the Supreme Court, reported in 2020, 7 SEC, page 1. Now, Supreme Court said, production of certificate under section 65B is mandated. If electronic record is produced before the court without certificate under section 65B, it is inadmissible in evidence. But on the merits of the case, based on the other evidence available on record, the judgment of the High Court was confirmed. But as far as the CCTV footage relied on by the petitioner, applicant in the election petition, court said the same is inadmissible for want of certificate under section 65B. However, judgment in Anwar was clarified. Whenever the primary evidence is produced before the court, certificate is not necessary. Even the statute itself is very clear on that. If you are able to get the original device in which the electronic records are stored is produced before the court, it is a primary evidence. There is no need to produce certificate as required under section 65B. In most of the cases, it may not be possible. The information may be available in our laptop. We may produce the CD or pen drive. If it is copied in pen drive and CD, it becomes secondary evidence. To authenticate proper copying of CD and pen drive, the person who is in control of the laptop should be examined, or he should give a certificate under section 65B. Now we cannot say he should be examined in view of the Supreme Court judgment. Suppose, what is the consequence if electronic record is marked as an tendered in evidence without certificate, whether it should accompany the evidence or it can be produced later on. That was also answered by the Apex Court. It said it is a curable defect. It need the certificate issued by the competent person need not accompany their electronic records. After production of electronic records before the court, the certificate can be produced before it is being admitted in evidence. In fact, this particular proportion I followed. My judgment reported in latest Law Weekly, it is 2022 File Law Weekly, page 721. Sudhir versus Kamraj. I followed Arjun Pandit and said it is a curable defect. The certificate can be produced even after production of the electronic evidence before the court. Now, the next question would be whether it can be cured in appellate side. The said question came up for consideration in one case law, Sonu versus State of Haryana, 2017, 8 Supreme Court cases, page 570. Here, the non-production of certificate under section 65B was raised before the Supreme Court for the first time. It was not raised before the courts below. Without objection, the electronic evidence was marked, electronic record was marked. At the time of argument before the Supreme Court, the point was raised. So it is, as far as objection as to proof is concerned, it is settled law. Objection as to proof has to be made then and there. At the time of tendering the evidence before the court, it cannot be raised later on. The underlying principle would be, if it is made at the time of tendering evidence, the person who tendered the evidence may have an opportunity to cure the defect. Supreme Court said that the certificate, the objection as to failure to produce certificate cannot be raised before the appellate court. But in a later decision, Pandit Rao, Supreme Court said, it is a curable defect. It can be cured, but before it is being admitted in evidence. You can tender it before the court, but before it is being admitted, the objection should be made. Before it is being admitted, the certificate should be produced to cure the defect. If it is marked without certificate, then it becomes inadmissible per se, in view of authoritative pronouncement of law by Supreme Court in Pandit Rao. It becomes per se inadmissible, like section 17 and 49 of registration. If a document, unregistered document is admitted in evidence, even thereafter it can be questioned. Likewise, if a unstamped document is admitted in evidence, even after admission, it can be questioned because it is per se inadmissible, inherently inadmissible. Therefore, non-production of certificate under section 65B is an inherent one. If it is not cured before the document being admitted in evidence, there ends the matter. It becomes an inadmissible document. Why can't we allow production of certificate in appellate stage? Why should we fix a cut-off limit for production of certificate? Because the only condition imposed by law is production of certificate. For production of certificate, no oral, in fact, oral evidence is not permissible. So even in appellate stage also, we can permit production of certificate. But I would like to request the members to go through the supplementing judgment written by Justice Ramasubramaniam in Pandit Rao case, wherein he said this 65B was introduced some 2 decades back in the year 2000. It requires revisit by the legislature. In view of the binding precedent, production of certificate is sine qua non for producing electronic records before the court. Otherwise, it cannot be marked. But the legislature can revisit it. Section 65B start with the non-abstract clause, notwithstanding anything contained in any other provision in evidence. Therefore, rightly Supreme Court said the 65B will prevail over other provisions, including 65. Now, it is for the ball is in legislature, unless it is revisited by Supreme Court. the most, 65B can only be an enabling provision. Any secondary evidence can be marked through the contents of a document. Electronic record is also a document as per the definition under section 3. The contents of a document can be proved by oral evidence subject to certain conditions under section 64. As far as electronic records are concerned, oral evidence is not necessary. Mere certificate is sufficient. So it is a concession conferred on the persons who produce electronic records before the court. The concession can always be waived by him, is it not? It is a concession in favor of a party who produce electronic record before the court. He can waive the concession and lead oral evidence to his detriment. If oral evidence is produced, the person who is in control of the main device before the court, he will be subjected to cross-examination by the adverse party. So it is not wise thing to produce a person who is in charge of the device who issued certificate. Anyway, as the law stands today, production of certificate under 65B is mandatory and it is sufficient. Pandit Rao case, the Apex Court also said, in case the original device wherein the informations are stored is under the control of adverse party, then it is open to you to issue a notice so that court can draw adverse inference. This is the march of law as on today. The younger members of the bar has to take the march of law to tomorrow. With these words, I wind up now.
Thank you, Lordship. We feel thankful for your teachings, Lordship. Thank you, Lordship. No duty is more urgent than that of returning thanks. Now I request our coordinator, Mr. C. Prithviraj, to deliver the vote of thanks.
Good evening to one and all. I feel honored and privileged to get opportunity to propose vote of thanks on this special occasion. I, on behalf of the Infotainment Club, convey my hearty thanks to our Honorable Mr. Justice S. Sounthar for having spared his time to be with us and your Lordship, inspired with your address, and it was been a wonderful lecture. My sincere thanks to the Chairman of the Infotainment Club, Mr. Vijay Kumaravel, for being a rock of support. I thank Mr. President and Secretary of MMBA, and I thankful to all the members of the Infotainment Club. My sincere thanks to all the respectable senior advocates, brothers and sisters. And I thank office bearers of MMBA, and I thank office staffs of the MMBA, and finally I thank Master of Ceremony, Ms. Rekha. Thank you all for making this event successful. Thank you.